Hello and welcome to the Asian Society of International Law 101, a space where we discuss international law scholarship from Asia, about Asia, and international law scholarship in general.
International law is usually considered as a conservative subject, with lawyers and judges emphasizing consistency and stability, predictability, and also a measure of advancement of the law over the domestic system. Greetings to everyone present. My name is Ankit Malhotra, and I am one of the co-editors of the book Reimagining the International Legal Order. This book is divided into 6 parts and invites a deep engagement with a wide range of topics that are detached from the endless feasibility skepticism that is often imposed on this law. This work provides a fascinating read for students, academics, researchers, but also practitioners such as barristers and solicitors in different jurisdictions across the globe on the wide areas of international law and relations. To discuss this topic, we have first amongst us Professor John Dugard, who is a South African lawyer specializing in international law and human rights law, and during the apartheid regime played a seminal role and directed the Center for Applied Legal Studies at the university in South Africa, a unit which was committed to litigation and advancement in defense of human rights. As the fall of apartheid, he participated in drafting the Bill of Rights for the new South African Constitution. In 2013, he was awarded the Order of Babua, which is South Africa's highest award for community service, and received several honorary doctorates from South African universities for his work. He has also played an instrumental role with international law, especially with the Lauterbach Center in Cambridge, where he has published widely in the fields of international and human rights law. He was also an honorary member of the American Society of International Law and is one of the most important members of the Institut de Droit International. He's also worked in the United Nations International Law Commission and also served as a judge ad hoc in the International Court of Justice and has held several positions in the United Nations and its functioning. We also have amongst us Professor Christina Ward, who is a professor of law in the University of Oslo in Norway, is a renowned expert in international environmental law, and is passionate about the legal issues of climate change, environmental multilateralism, and sustainability. Professor Ward has also worked on legal issues of climate change, environmental uh, conservatism, and is a frequent speaker of international and national importance related to these issues. She's also the chair of IUCN, World Commission on Environmental Law. For almost 10 years, she's also worked as a legal advisor and negotiator for the Norwegian government in the UN climate negotiations. She is currently the co-chair of the Paris Agreement's Compliance and Implementation Committee. Last but certainly not least, we have amongst us Professor Dr. Sergei Sayapin, who is a professor at Kazakhstan and has studied law in the University of Uzbekistan and the United Kingdom as well, and Germany, and has held several doctoral positions in the regional delegation in Central Asia and has worked in the International Committee of the Red Cross. He also teaches and researches on interests of Central Asia and post-Soviet approaches to international institutions in the law, international comparative criminal law, criminology, law and society, economics and technology. I welcome all our speakers to this discussion, and I hope that this discussion and also the book will provide a starting point for discussion and dialogue, and by no means considers itself to be the end point of this discourse. This book is a labor of love and also emanates from the crises that we found ourselves in a few years ago, namely during the COVID-19 pandemic. And one is therefore reminded of the famous words of Sir Winston Churchill, who once famously said, "Never let a crisis go to waste." So as a young scholar, a student at the time in his LLB studies, this book was utilization of time and a deeper study and discourse, not only with an aim to fulfill a gap, but also to deeply explore the crevices and also the circumstances of law and also its wider impact in society. We are limited on time, so I should jump right into these questions. And Professor Duga, the first question that I have for you is, in this shift of international law to rules-based order, how do you perceive the implications of this shift, especially while considering the paralyzing influence and also occurrences of powerful nations in the Security Council specifically? So,
the rules-based order or the rules-based international order is a concept which has emerged in the last few years, in particular, since the Biden administration came to office in the United States. And it's a term which is widely used by Western politicians, but it has not been defined. So we don't really know what it is. It could be seen as a synonym for international law, another name for international law. It could be seen as a name for little international order, which includes sources beyond the traditional formal sources of international law, or it could be seen as an alternative to international law propounded by the West. And I must say that at present I incline to the last view. It's very interesting that President Biden very, very seldom uses the word international law. He always talks about the rules-based order, as do his administrative officers, particularly the Secretary of State, Antony Blinken. What it in effect means is that there's another set of rules which determines the behavior of the United States. And you'll ask, why is it necessary to have another set of rules? And I think the reason is that the United States is really out of step with the rest of the world. For instance, it's not a party to some of the major international treaties, such as the Law of the Sea Convention or the Rome Statute, or the Convention on Cluster Munitions or Anti-Personnel Mines. It has its own interpretations of international law, particularly when it comes to the use of force. We hear so much about the rule-based international order, but we don't know what the rules are. We don't know who makes them, and they're clearly not subject to judicial settlement. So it's a very dangerous phenomenon, I believe, and as I've indicated, we now see it in full force in the Middle East, where the United States and Western states, particularly the United Kingdom, simply failed to observe basic rules of international law. And of course, we see it in the Security Council as well. The United States has recently vetoed resolutions on securing a ceasefire in Gaza. And I think that's because of their interpretation of the use of force. They see Israel as being allowed to use force which goes beyond force permitted by the Charter of the United Nations. So I think it's a interesting development. And what is interesting for me is that it's one that does not seem to have troubled international lawyers. Political science experts debate the meaning of the term, but lawyers simply avoid it, despite the fact that it does threaten international law.
Thank you. It's quite insightful, and I'll sort of pick up on the thoughts that you've raised in this, and especially engage you with the dealings that you in your personal capacity have had over the past decades. And how do you think that these personal histories and these personal stories can help identify and also engage with this international order? And perhaps it would be most illuminating if you can speak about the Israel-Palestine issues, as that is perhaps one of the most trending topics, which requires deeper insight and study as well, and the multiplicity of narratives flowing around in the air.
Well, you asked me to speak about my personal history in the first place, and let me stress that I'm a South African, and in apartheid South Africa, I looked to international law for salvation. I believe that international law, international human rights law, as applied by the ultimately result in a democracy in South Africa. And this took many years, but it did in the end prevail. The international community took apartheid very seriously. But now we see that international law does not apply in other situations where the Western powers believe that one of their members is threatened. So the United States and the European Union and the United Kingdom and other Western states take the view that Israel is in effect above the law, and they're not going to insist on compliance with international law as they did in the case of apartheid South Africa. So this has resulted in tremendous disillusionment on my part. It's very difficult to be an international lawyer at present.
That's insightful as well. And South Africa also brings to mind the paralysis that happened in the General Assembly vis-a-vis international law, and especially the International Court of Justice, and how the states chose to avoid going to court under any measure. Do you think that the General Assembly, given its current situation, can have any sort of impact or any sort of stress on the situation? Or do you think the United Nations, perhaps as a body, also needs, shall we say, reimagining?
I think the General Assembly has powers at present which it could use. Obviously, it's going to be very difficult to expand the powers of the General Assembly by means of amendment to the Charter. In fact, I think that is impossible. But in the present situation, for instance, in the case of the ceasefire in the Middle East, there's no reason why the General Assembly should not invoke the United for Peace resolution. The United States vetoed a Security Council resolution. The United Nations General Assembly could exercise powers under the United for Peace resolution and call a ceasefire. It's also clear that the General Assembly could go further in resolutions that it adopts. Again, to revert to South Africa, in the case of South Africa, in the early 60s, called for an arms embargo on South Africa because of the policies of apartheid.
Right. I thank Professor Dugat for his comments. I'll now move to Professor Ward, whose chapter is titled Ecocide as a Crime for in the International Community to Consider, and also to look at seriously to protect the environment. And the first question that I have in that regard is, to what extent do you believe that the proposed definition of ecocide balances environmental integrity with the existing provisions within the Rome Statute? And perhaps if you could also caveat this with your involvement in the discourse that took place on ecocide.
Okay, well, thank you for the question. And before I attempt to answer it, I would like to congratulate you for that fantastic book that you edited. I think it's a real interesting contribution to the general discourse on international law, and it's very, very welcome and very, very much needed. Back to your question on ecocide, maybe first to my involvement. I was a member of the expert panel on a legal definition of ecocide, which was set up a couple of years ago by the Stop Ecocide Foundation. We were 12 international lawyers from very different backgrounds who were asked to provide an informal proposal of how ecocide could be defined as a new international crime. And behind that initiative was the consideration that some of the most severe environmental destruction maybe currently has come to the level of crime, of severe crime, of most serious international crime, because it does affect the community of life as a whole, and individuals and states as a community. So what these 12 experts did was to propose a possible definition, but the idea was only to give an idea to states if they wanted to, if they saw any merit in that definition, to take it further and maybe start a discussion about the feasibility of including a fifth international crime of ecocide in the scope of the Rome Statute. Now, this hasn't happened yet and hasn't started yet, but what we've seen in the meantime is that in many national jurisdictions, discussions have started whether criminalizing most severe environmental destruction is perhaps a way forward to include environmental destruction in the overall scope of the regulatory framework.
But do if you look at it from the other perspective, if this does get included in the Rome Statute, do you think the national approach was therefore get catapulted or accelerated, especially given the economic, perhaps also the environmental degradation that takes place, especially within the jurisdiction of the ICC, which is now dealing with issues other than the crimes against the environment, such as war crimes, crimes against humanity, and the new crimes which are taking place as well, and the new circumstances we find ourselves in.
Yeah, well, it's hard to say, you know, as a hypothetical, what would happen if. It's difficult. But I do think that an inclusion of ecocide as a new international crime would give a very important signal, a legal signal, a political signal that destruction of the environment above a certain, severe threshold is something that has the stature of a crime. I think that should not be under evaluated or evaluated what that kind of signal is. But the important issue why we consider it a fifth international crime, an additional international crime, is that what we're seeing currently in terms of environmental destruction primarily happens through peacetime, right? It doesn't presuppose a military conflict of any sorts. Of course, there are environmental consequences of military action, and we see that very clearly in the Ukraine, for example, through the Russian attacks. But much of the environmental destruction happens through peacetime, and quite a significant part of it is actually legal. There is, under international law, very little that actually prohibits environmental destruction. Most of the international law that we have under international environmental law is primarily procedural in character. States have to carry out environmental impact assessment, they have to inform each other, they have to cooperate, collaborate, they have to provide information. But there are very, very few substantive legal norms in international law that would, prevent environmental degradation. And in that kind of vacuum that we are seeing, at least the criminalization of the most severe environmental destruction could perhaps also help the development of other areas of international law, and maybe taking environmental degradation and destruction more seriously, also from a substantive legal perspective and not just from a procedural one. So these were some of the considerations that we had when we elaborated that definition, which I wrote about in your wonderful book that you edited. And as I said, it was very important to have lawyers, international lawyers with very different backgrounds in that small panel, because there were international criminal lawyers, public international lawyers, international environmental lawyers, and so forth. And having the discussion, what do we have in international law? What is needed? Why is criminalization an issue? Why is it warranted? Were extremely interesting discussions, and I think the definition that we came up with reflects a fair balance between different considerations.
And how much of a reference did you pay, or how much research did you do in terms of looking at national jurisdictions and domestic systems? Because what I've seemed to have found is that there are these nuggets here and there, especially in the case of Vietnam, which has domestic legislation within the system, but you also have the Eastern European states, former USSR territories, who have these legislations. So if you could share some insights as to the travel that you did, but also how much of a reflection and how much of an inspiration did you take while you were looking at these domestic legislations?
Well, we were well aware that the discussions around ecocide, they're not new. They date back like 50-something years. And in those 50 years, a lot has happened. Like you said, in several national jurisdictions are now crimes of ecocide either included in the National Penal Code or even some constitutional provisions, or there have been attempts both in national and international law to define ecocide. We had a wonderful and quite full data set available to us with all the existing attempts to define ecocide and how far they've come. That was something that we had a very close look into. But when it comes to the proposal of how perhaps a fifth international crime in the context of the Rome Statute could look like, we also had, of course, to extrapolate that to the international level, where, for example, whether something is justified under national law does not necessarily play a role in international law. As we all know, we had to look at the other areas of international law and how well do they regulate environmental destruction. So that's a very different level of a deliberation that we had to do, in addition of knowing, what's happening in some national jurisdictions. But we were informed by these attempts, and they, framed a little bit of our thinking. But I think what we did was really plowing new ground in the way that we discuss and propose, for example, also looking at not just at illegal acts, but also at legal acts that are wanton, where there is a significant disparity between the negative environmental consequences and any possible social or economic benefits, and the negative consequences are completely disregarded, knowingly disregarded. I think that's a new approach that we put forward. It was criticized from all sorts of different camps for going too far, all the way to not going far enough, which is very difficult, which may actually indicate that we got it quite right in the middle. But it was interesting to see the reactions primarily from the academic community after we launched the definition, which was supportive, but also there was very interesting critical discussions, which are very important, of course, to shed light on that issue from very many different angles.
Right, thank you. I'll now move to Professor Sayafin, whose chapter is titled Rethinking Humanitarian and Human Rights Institutions for Asia. And from Eastern Europe, perhaps, to Asia and Central Asia, and also the larger Asian belt that the chapter deals with. My first question to you, Professor Sayafin, is, in light of Asia's complex political and legal landscape, do you evaluate, and how do you evaluate, the establishing sub-regional human rights committees or commissions with oversight functions?
Thank you, Ankit. Well, in fact, I think that this is the most practical, if not the only feasible way to introduce institutional human rights mechanisms in Asia. Asia does not presently have a regional human rights court, like the European Court of Human Rights, or like the human rights courts in the Americas or in Africa. And there are good reasons for it. Asia is too diverse in terms of culture, in terms of legal traditions, in terms of languages spoken, and in geographical terms, Asia is too vast. So taking together these factors make it quite difficult and to establish a single human rights court for a region that is so vast and so diverse. And so I think that if regional human rights institutions were to be established in Asia, then these should probably be sub-regional mechanisms, such as human rights committees or human rights commissions, or maybe even sub-regional human rights courts for various parts of Asia. For example, for Central Asia, for South and Southeast Asia, for the Middle East. Also, given that these different sub-regions are representative of the respective legal traditions. For example, the Central Asian countries are all civil law countries. So based on the civil law tradition, whereas in the Middle East, Islamic law prevails, whereas in the South and Southeast Asia, the influence of common law is quite significant. And for all these practical reasons, I think that the relevant groups of Asian states might come together if they wanted and consider establishing such sub-regional human rights mechanisms in the most appropriate formats.
What about institutions perhaps that are already set up, and something which you touch in your chapter as well, such as the ICRC, the role of established institutions within the region as well, helping out countries, war-torn countries like Afghanistan, uh, terrorist sponsored states as well are in the region, which shan't be named. But these how do you see the influence of the current institutions in shaping the human rights discourse that takes place, and especially in the context of the challenges that you've mentioned and highlighted in the book as well?
Well, since you have mentioned the ICRC, the International Committee of the Red Cross, uh, I'd let me say a few words about it. The ICRC is a particular case in the context of the human rights discourse. It is not a human rights organization, and when I joined the ICRC 23 years ago, I remember my first boss telling me not even to mention human rights in public, so that various interlocutors of the International Committee of the Red Cross do not confuse it with human rights organizations such as Human Rights Watch or Amnesty International or any other human rights organization. The ICRC has traditionally been involved with international humanitarian law, and it wants to remain so. It wants to maintain this distinct identity. But what was significant, in 2006, the ICRC adopted a doctrine which now enables it to invoke selected human rights, in particular selected civil rights, such as the right to life or the prohibition of torture, or rights pertaining to the family unit and to the prohibition of forced labor, particularly in situations of armed conflicts and other situations of violence. And so now the International Committee of the Red Cross, when it chooses that such invocation is appropriate, now it can invoke these selected human rights, in particular in the context of detention, in the context of human rights protection in situations of violence, such as riots, demonstrations, and similar situations. And I suppose that given that the ICRC is often the only humanitarian institution present in challenging contexts, such as Afghanistan, there the ICRC has been present for decades, and given the prominence of China as a crucial regional actor in Asia, but also worldwide, I suppose that the International Committee of the Red Cross might invoke, in accordance with its appropriate procedures, selected human rights, especially in Afghanistan and in China, to protect vulnerable populations in those countries, such as women in Afghanistan or the Muslim minority in China.
Can you just expand on that? And I know that you do this in the chapter, but I just want to zoom in on this point of the involvement of an institution like this, which can have such a penetrative impact on the society writ large. So if you could expand on the examples that you've just highlighted in Afghanistan, in if an involvement in Myanmar as well, and other regions, just for the benefit of the viewers, I think that would be quite interesting.
Well, then I should probably say a few more words on the current ICRC approach towards human rights. As I said, 23 years ago, it was a almost a prohibited topic in the institution, and it was a matter of principle because the ICRC did not want to be confused with human rights organizations. And so in now that that position still remains. The ICRC is not a human rights institution, and it's stated in the doctrine of 2006, which I mentioned earlier, very clearly that the ICRC bears no institutional responsibility for the application of international human rights law, that it's not a human rights organization, and also methodologically, it does not employ the campaigning methods, the publicity method, the naming and shaming method, which are so typical to human rights organizations. However, as a matter of practice, human rights, those selected human rights which are of concern to the ICRC, they often overlap with relevant provisions in the documents of international humanitarian law. In a certain sense, all international humanitarian law is about the protection of the right to life in armed conflicts. And so, to the extent that the non-derogable human right to life overlaps with international humanitarian law and with permissions on the use of force allowed by international humanitarian law, so the ICRC now is institutionally able to appeal to states and to remind them not only of their obligations under humanitarian law, but also under the relevant obligations under human rights law, in particular, as far as the right to life is concerned. Or else, if we speak of the prohibition of torture, clearly, this prohibition is present in the Geneva Conventions. It is present in Article 3, common to the Geneva Conventions and applicable in non-international armed conflicts. But to the extent that the International Committee of the Red Cross operates not only in armed conflicts, but also in other situations of violence not reaching the threshold of armed conflicts, in which IHL does not apply. And also in many countries of the world, the ICRC does humanitarian visits to places of detention in peacetime. And in such situations, international humanitarian law is not applicable, but the prohibition of torture under human rights law is valid. And so in contexts like this, for instance, where the ICRC does humanitarian visits to places of detention outside armed conflicts, the invocation of the prohibition of torture under human rights law is very appropriate.
Final question. Do you see, and we did discuss this in another discussion as well with you, is that do you possibly imagine or envisage a court, or maybe you do envisage a commission, but do you see the possibility of a court in Asia for protection of human rights? I do sort of know the answer, but I'll let you share your reflection this briefly, and then I'll open it up for comments from the other panelists on the reflection shared by one another.
Well, idealistically, or ideally, I would like Asia to have a human rights court of its own. Having said this, I repeat that there are significant practical obstacles to the establishment of such a court, but if you think about it, these obstacles are not insurmountable if you, if Asian states really wanted to have a regional human rights court of their own. Yes, Asia is vast, and it is not easy to answer in which major Asian city the court should be located if it ever were established. Should it be in Istanbul? Should it be in Tokyo? Should it be in New Delhi or Beijing, in Singapore or elsewhere? If there were political will to this effect, a decision could be found. For example, several regional chambers of such an Asian human rights court could be established in different places throughout Asia. The linguistic problem could also be overcome. Yes, Asia has many languages, but if there were a political will to establish a court or several sub-regional chambers, then solutions in terms of languages to be used in the court or in the chambers would also be found. And last but not least, even the geographical challenge could find a solution of its own. Asia being vast, there could be several chambers of the court located in different sub-regions, plus if a decision were made to also establish a human rights commission like the one which existed in Europe and which exists in the African human rights system. So if there were also a commission additional to the court and doing the pre-screening of applications to the court, offices of the commission could also be scattered throughout Asia, and this would make access to the court easier in geographical terms. So challenges are there, but solutions can also be found depending on the political will, I believe.
That's quite illuminating. I now open the floor for questions or sort of comments from the other panelists. If we don't have any, then we can end the session now. Professor Dugard, do you have any reflections or comments on the speeches made by others? Or
yes, I was interested in her comments that we made before the meeting about the possibility of using the International Criminal Court for ecocide. My own view is that the International Criminal Court at present is largely dysfunctional. It is totally preoccupied with the prosecution of President Putin and does not allow itself to consider wider responsibilities such as the prosecution of ecocide or international crimes involving the environment. So that is a subject that really troubles me.
I think there are two different issues here. One thing is what the International Criminal Court currently does and how dysfunctional it is or isn't in the current situation. But even with regard to the arrest order for President Putin, I mean, there is even scope to consider the environmental impact in the Ukraine under the existing rules of the Rome Statute. When it happens, then environmental impacts happen in the context of crime against humanity or war crime, we have the possibility to include them, and that there is nothing that would prevent the office of the prosecutor to extend that into the current situation. But what we were talking about was a potential possible additional fifth crime, which would be something for the assembly of the state parties to consider at any given time in the future. And if it were to be included, then that would of course raise the question: how would the office of the prosecutor deal with such an amendment if it were to? But these are very different discussions to be had. One is the question of state parties' willingness to even consider an amendment of the Rome Statute, and then the negotiations that would follow, and the whole procedural requirements that we have for an amendment of the Rome Statute. Another issue is what you very rightly pointed to, the current situation, which is a very challenging and difficult one.
Thank you very much. I've enjoyed thoroughly both presentations. My only quick question for addressed to Professor Voigt would be, to what extent is it an obstacle to the introduction of the new crime of ecocide into the Rome Statute? So to what extent is it an obstacle that, unlike the other crimes which currently are penalized under the Rome Statute, such as genocide or war crimes or even crimes against humanity, so all those are already reflected in treaties, in dedicated treaties of international law, such as the Genocide Convention or the Geneva Conventions. So the crime of ecocide is not similarly based in pre-existing treaties currently under international law. So to what extent is this an obstacle to the introduction of ecocide as a new crime? Thank you very much.
Yeah, and thank you for this question, because it does point to the significant difference in the situation that we have with respect to ecocide as compared to the already 4 existing crimes, which already, as you said, were either part of treaty law or customary international law, already crimes, and they were then elevated to the level of the most serious international crime and fell then under the jurisdiction of the ICC by being included in the Rome Statute. This is not the situation with regard to ecocide, and of course, I alluded to this issue a little bit between the lines of the question: do we need to see legal developments in treaty law first, or perhaps in international customary law with respect to the protection of the environment, before we can then start discussing criminalization? Can that happen at the same time, or can the signal about the criminal aspect of most severe environmental destruction come first and inform other areas of law? I don't have the answer to that, but there's a very interesting inherent dynamics that may come to play that could enhance each other, or maybe obstruct each other. That is also a possibility. But I thought it was a very important question because we're indeed dealing with a very different starting point compared to the existing crimes, which were difficult enough, of course, we all know the history, to be included in the context of the Rome Statute. But I was having questions too, if I may. I did enjoy both presentations very, very much, and the respective chapters as well. I do have a question to both presenters, to Sergei first, perhaps in the context of human rights. We currently see several developments within the European context, but maybe also the inter-American context, on human rights by kind of an extension or recognition of the existence of a human right to a clean, healthy, and sustainable environment, as the United Nations General Assembly recognized in its resolution from last year, as well as the Human Rights Council, and something that already has been part and parcel of the inter-American context on human rights. How would that translate into the Asian context that you discussed? Is that something that we will also need treaty law to develop accordingly? It's probably not done by a UN General Assembly resolution if it's not followed up by actually being included in the treaty body. And an additional question is with respect to the current cases that are being heard and pending at the European Court on Human Rights with respect to interpreting the European Convention on Human Rights in the context of climate change, where we have had several hearings, that no decision has been taken yet, but where suddenly a very different and global context is being applied to the interpretation of existing human rights, for example, right to life, right to health, Articles 2 and 8 of the European Convention. And it would be interesting to hear your thoughts on the feasibility, or maybe also the necessity for these traditional existing human rights being interpreted in a new context. And to Professor Dugard, with respect to a human international rules-based system as opposed to an international legal system, if I understood you correctly, is there also potential for harmonizing both? Do they necessarily have to be two different things? Or can a rules-based system be understood as the rules of international law, so as to avoid any additional or sidetrack or carve out to bring in rules that nobody has heard about and we don't know where they come from, and they're not falling under judicial review, as you said? But with that, back to you, Mahota.
So as for the applicability of environmental rights or the relevance of environmental rights in the Asian context, this is very, very important. given that Asia is now on the rise in terms of economic development, in terms of industrial development. It's also a fact that Asia's environment has been exploited for decades by major Western businesses, which were transferred to various Asian countries due to the relatively cheaper costs of production. And so in Asia, it is now the right time to reinforce their environmental policies, to reinforce environmental protections for the sake of humans, but also for the sake of the environment itself, because the environment obviously has a value of its own. And as for the relevance of environmental human rights in the other context, in Europe or elsewhere, I am glad that the respective regional human rights courts are interpreting the relevant conventions in creative ways, and give the conventions new meanings that probably were not even intended decades ago when the conventions were adopted and enacted. And there are good justifications for this, because the environmental situations in the 1950s, when, for example, the European Convention was adopted, was very different than it is now. And so the European Court of Human Rights is to be praised for the efforts it is now making to place environmental concerns on the agenda. Thank you very much.
May I answer the second question about the harmonization of rules-based order and international law? I really don't think there's any prospect of this happening, because the Western world wants to have its own set of rules to dictate to the rest of the world. And the reason for the RBO, rules-based order as I see it, is essentially to exclude international law as it has developed, where this is inconvenient to Western policies and practices. I would very much like to see the two harmonized, but quite frankly, the difficulty is I don't know what the rules-based order is. We hear President Biden speaking about it, but it has yet to be given any content. And so it's a real mystery to me, but I think it's a sinister mystery.
Well, that was quite precise as well. I do want to take this moment to thank all the panelists for agreeing to do this. A special thanks also to the Asian Society of International Law, perhaps most especially to Professor Anthony Yankee, whose tutelage the society has formed, run, and also managed quite expertly. Final thanks also goes out again to the panelists who've contributed chapters to this book and made this imagination come to fruition. And also, as a young scholar, I'm thankful to them for their support.
Thank you for joining us at the Asian Society of International Law 101, and watch this space for future conversations.